Hello, everyone, and thanks for joining another filerskeepers webinar. I'm intending to just get right into it. Today, we'll be talking about training data, logs, prompts, all about AI data. How long are we supposed to keep them? I'll be talking about this. I'm going to talk about a few other topics as well. But first of all, welcome. And this session is being recorded, so you can rewatch and share. We'll be sharing the recording with you after this, and it's always fine for you to come into the Q&A and ask questions. I'll try my best. I got it up there, and I can see the Q&A, so I'll take questions whenever. Always love to answer questions. Grab a coffee, or if it's late for you, something else. Yeah, thanks for joining. I'm very excited about the future. We're a very optimistic company, and our prediction is that data retention will completely be solved within the next 3 years. At least we're trying our very hardest to make that happen. I also believe with the onset of more connectivity between systems, APIs, MCPs, and also AI, that we can really solve the issue of records retention and finally implement retention in all systems. And we definitely see a large part of our customers make great progress there. So it can be done, guys, really. And also, yeah, I think that the end of unstructured data is near. We just need a little more push from AI. So I'm Wanne Pemelaar. I'm the co-founder and currently CEO of filerskeepers, and also a baby company called Lawstronaut that I would love to tell you a bit more about. What filerskeepers does, for those of you who don't know us, we read all the laws in the world, and then we take from their rules that tell companies how long they should store their records and data. And then we help apply those rules to the records and data of our clients, first and foremost by building retention schedules. We have a dashboard where you can say, hey, I'm in these jurisdictions, these industry, please build me a bespoke retention schedule. We do that for over 4,000 multinational clients, and we pride ourselves that we have all the countries at national level in our database, and also all the states that you would expect from us. Together, that's 357, almost 58,000 legal citations, the biggest database of its kind. And maybe for those of you who expect us to be completely disrupted by AI, we are running a lot of our AI ourselves also, and actually it's the AI companies that are coming to us right now for our data. I think I'll just skip some of this, but this is the dashboard that we have. I'm also the CEO of another company, and I just wanted to kind of highlight that because Lawstronaut and filerskeepers really work together. Lawstronaut is I think last week turned 1 year old, and it's doing really well as a company. I'm even expecting it to be a bigger company than filerskeepers. What we did there was, well, with filerskeepers, we have that big database of retention periods, and the human effort to keep track of changes in laws and updates to those rules appeared to be too much work. So we created a machine that crawls the internet, crawls government portals, finds the laws, the regulations, the case law, the legislative history, the regulatory guidance, or regulatory decisions. And filerskeepers became kind of like the biggest client of Lawstronaut. We use it for retention research within filerskeepers, but the raw material is much coveted by many legal tech companies, AI companies, and now also legal departments because legal tech AI struggles with poor data quality. It's getting better, but it definitely, Claude doesn't know what happened yesterday. So yeah, we often say that we sell the speed and completeness of legal data. So inaccuracies, distrust in AI leads to poor adoption and and maybe also a poor legal standing. And there's, for example, the Moore versus Del City case. So what we now did was we created a crawler, and within a year we got 30 million legal records in there in 115. Oh, sorry, you guys are telling me that my whole screen is not available. Uh-oh, that's super bad. I do apologize, guys. That's such a rookie mistake. I hope you guys can see it right now. All right, you missed about 9 slides for me. I do apologize. Can we see it all good? Salsa, can you let me know? All right, so 30 million records in 115 jurisdictions. We update a lot of those portals daily, and if we don't do them daily, we update them weekly with about 40 team members. We didn't just build a crawler, we built a legal infrastructure. We can parse PDFs at ginormous scale. We can issue an infinitive number of crawlers, and we can do that at a very, very low cost. And that means that now you could plug your AI agent into that database. So, for example, you could literally ask, hey, what changed yesterday on AI privacy and employment law across my key jurisdictions? And then the AI agent, say you use Claude, can go to the Lawstronaut MCP or API and then receive an answer. We're kind of like hacking the legal space here, because this would be a way cheaper setup than any of the other legal techs. Anyhow, just shameless commercial for Lawstronaut. Let me know if you need to know more about that. I'm going to get into what we really want to talk today. So let's go put our AI and records management head back on. So we're in the world of filerskeepers, and our assignment today is to basically remind ourselves that AI prompts are covered by the GDPR, and that records management and AI really, really link closely together. And then we can talk about the retention periods for AI prompts and all of that. And maybe if we have some time, we can talk about the future of records management, how I see it, and how it can help AI get even better. Because if you know what I know, we're just getting started with all of this. Because if we do records management well, the AI can become the company, to be honest. So we've all bought into the pledge of AI. That's why you're here. It's gonna make our life so much easier. Everything will happen, of course. It's gonna revolutionize industries, enhance decision making, personalized experiences, scientific progress, and of course, we're also very much afraid. What is it gonna do? Is it from job displacement basically to existential risk? I'm gonna do a little reality check with you, because even though people think it's a true gold mine, as long as AI is built to preserve energy and reduce cost of operation, it's gonna cut corners. It's gonna, if you give it a ginormous task, we have AI agents, and we also, of course, ask it, hey, could you please let us know if there's any new retention periods in the last half year in the UK? If that happens, it will be confronted with such a bulk of information that it goes, whoa, I am not processing this for this price. Yeah, you're not paying me enough to use this much energy. So then the model has been like Claude or OpenAI, doesn't matter which one, any of them will then say, I'm gonna summarize, I'm gonna skip things, I'm literally gonna truncate the law. So even though the clause within the law is 100 words, I'm gonna cut it off at 20. Well, then you lose all the meaning, right? And that's kind of like, then you get the worst hallucinations ever. But that happens even with the most, top tier subscriptions and use that you can get. So what's the alternative? On-prem, I think, and that's why you see now also a lot of folks going on-prem with their AI. But then also, even on-prem, you still have a model that needs to preserve energy. Energy is limited within this world. So we've all kind of understood that the data itself has little value. That's already pre-AI times, but it's all about the use of the data that determines the value. And all was well, of course, and we could all use our data freely until the GDPR arrived. I'm exaggerating like crazy here, but I've now added to this slide, and the AI Act arrived. It's very clear that the European Parliament wants real compliance, and that will be a theme in this presentation, but also in all presentations that I give. I'm always looking for real compliance. And records management has become mission critical in the age of AI. You want data to be clean, classified, structured, governed, and trustworthy. And your data, look at your like Microsoft setup or Google setup. It's just not that. I see that with all our clients. And a lot records managers know a lot. They know that the organization itself can become the metadata and the ontology, and the sign out logs can be the audit trails, and a filing structure can become a taxonomy. So the records management industry has known certain truths for a long time, and it's now that we see that all the cool AI lawyers are suddenly waking up, and they go like, oh, if only we would have killed all the rot in our systems, all the redundant, obsolete, and trivial data, then our Copilot would really work. Our Copilot is not working. And the problem is not your Copilot. It's all good. It's not your OpenAI. It's not your Claude. It's just that, Copilot inherits whatever the mess is that you've already built. So if you share access with everyone for a file, then, Copilot will have access to it, because the default setting within, a Microsoft 365 SharePoint document sharing is everyone. That's the default. If you don't give the link to someone else, then you feel like this false sense of security, because you're like, I just gave the link, which technically says share with everyone, just to this one person. So I'm sharing this document just with one person. But now AI doesn't look at it like that. It goes share with everyone, also with me. No retention schedules, no sensitivity labels, content sprawls, no information architecture. It's all very much needed in order to get to the right place, especially if you want to run your AI on unstructured data. And AI is just more of that, yeah? So it can create the data, and it does that at a speed that we can't even comprehend. How come we could get, go from zero to a full-fledged legal tech startup called Lostronaut in 1 year? AI, of course. It goes so fast. Once the bad someone is asking, once the bad data is in, even if we make these corrections, will that improve the responses? Yes, I would say so. Yeah, so a request is always looking actively at current data, at what's in there. You might have a bit of legacy, a little bit of memory, but those memory windows aren't big enough yet. Again, processing power, again, economic decisions. So it's like you will have like this brilliant um, Einstein level robot that can do everything you want, and this colleague that can do everything you want, but with a little bit of amnesia. Yeah. So if you fix your data now, that definitely will help in the future. And otherwise, you just do a reset and you start over with a clean batch of data, of course. But AI is good at handling information. It needs a lot of data, but it also needs a lot of good data. Garbage in is garbage out. It's very corny, but it is the truth. So but it will add to the bulk of data. And one of the very interesting questions nowadays is AI data, is that a business record or not? And there are I'll dive a little bit more into that in a minute, but there are definitely arguments you can make in favor and against that, basically. So the question is to keep or delete. You want to keep. You want to have that data in those models. The laws tell you to keep data, and in litigations, it can mean the difference between winning and losing a case. You can't prove your position, you can't win. And then, of course, companies want to forget because privacy laws, because of all kinds of other privacy related laws that tell you to destroy data. And yeah, the bigger the volume of data, the bigger the breach if you get hacked. You can win a litigation, you can also lose litigation if you hold on to certain records. Yeah, those are reasons. But yeah, it's the problem that companies are still struggling with, even though we've turned on all the AI machines. Like, how long do we store records? Yeah, you have three issues there. The first one is you don't know what the law says. Well, maybe you use filerskeepers, so you do now. But then you don't know what to choose. Maybe we build a retention schedule together, so now you know. But then the biggest challenge is always going to be implementation, and it's not sexy, but it's necessary. You have all the challenges there: hard copy, digital, global, local, cloud, on-premise, structured, unstructured, current, legacy. And I'm very proud also that with filerskeepers, we're now getting into the direction of more implementation. There's a lot that we can do there, but we really want to kind of be the dashboard that drives the compliance. I'll discuss that more in a follow-up webinar. So what is a business record? Sorry, this is a bit of an old slide. It's 2023, but what is a business record in 2026? It's a set of data. It's no longer that old final contract that was printed and signed, and well, it's still that, but it's not just that anymore. It's collaborative workspaces, workflows, it's data driven, it's maybe even AI generated. So is AI is what AI generates a business record? Well, probably not if it's just a bunch of slop, a bunch of rot, drafts, things you use for the end result. Then not, no. But does it become a business record if it is personal data? If it gives the intention of the user? If it gives an advice that gets actioned? If it discloses certain information on someone else? It could be a breach. Even in Italy, the Garante, the Italian Data Protection Authority, has said that if the AI hallucinates, for example, about the CV of a person, that's already personal data, even if it isn't true, because it can be used to impact the person. So from an official business record perspective, most often you want to say, no, that's not a business record, but then the GDPR can swoop in and kind of give this away more formal status, and then a court can suddenly care a lot, because maybe you get, sued for copyright breach or something, and then suddenly this becomes part of a legal hold discussion. So I would assume that it is a business record, even if you don't want it to be. So that's something to think about. I've already spoken about this, but I do believe that the end of unstructured data is near. And the reason why I say that is that with AI, we can structure anything. And there are some, like Claude by Anthropic is just brilliant with categorizing data and records. So I do believe that we're very near. I think the only thing that's holding us back is that the economics of things aren't there yet. But as Moore's laws, or I think the CEO of NVIDIA said NVIDIA law progress, then this will be cheaper soon. So compliance sounds easy, but it isn't, because the laws are hopelessly conflicted. And so the choice part and knowing the law remains difficult and remains risk-based, and there's no other way around it. The good news is that a few data protection authorities are now also using filerskeepers, so they are kind of familiar with the fact that it is a risk-based approach, because there are so many rules. Yeah. So you're forced to make choices. You're forced to kind of implement one golden standard with a few exceptions. Think about this. If you're in 50 countries and you have 200 record types, that's 10,000 results. So your schedule could have 10,000 rules in it. But if you don't want to plug that into Microsoft, you will not be able to move it even into Microsoft Purview, because Microsoft Purview, where you would hold your retention schedule to implement into Microsoft, can only hold 1,000 line items. Yeah. So you have to condense that. You have to build a golden standard, maybe with a few deviations where you can say, hey, this country has a longer minimum, shorter maximum. So Arma once asked me, the American Records Management Association, can e-discovery and scanning be used, for all of this? Can it fix, the part of knowing what you have and becoming way more granular, basically? And then my answer is yes, but there are issues. And when you look at, okay, I'm going to clean my data up for AI, then please know this: a lot of those vendors in the e-discovery land are focused on cybersecurity use cases. They want to find, data elements of high risk and set the confidentiality levels. They're one-trick ponies. They don't have any expertise on records management compliance, and no way that they can map a retention schedule to a classification. So what you want to do is you want to find tools and approaches that actually take a broad data and records perspective, searches for context, uses data lineage, or even my favorite, provenance. It's even better, to understand the context of the content, ingest retention schedules, does the end-to-end data mapping to the classifications, and also knows how to remediate the data in the source system. That's what you want to look for when you are out searching for a data discovery tool. And I believe that we also, and that's a bit of a problem nowadays, and I really feel very dearly about this, that a lot of the AI and privacy lawyers now come to the conclusion that records management is important to AI, to proper AI. But then they also noticed that they just fired their records manager, or that the organization, the records manager, retired, but they never replaced the person. And that's why I really want to make a heartfelt plea for anyone, not in the records management space, maybe in privacy, maybe in legal, to really embrace the records manager and to teach them the skills that they might otherwise be lacking because they're coming from the hard copy storage world. But they are the guardians of data minimization. They understand retention, they understand purpose limitation and security. And with all due respect, that is the essential toolkit for the CPO or the head of data. The things like data quality, data minimization, retention are usually on the plate of privacy, but privacy usually doesn't touch that because they say it's the business that needs to deal with that, or it's another staff function like legal, compliance, or IT that needs to deal with this data governance. But the records manager knows thousands reasons to keep data. They understand when it's time to delete, and they really understand what the business is about because they've seen all the records for decades, and they understand the business like nobody else. So they also understand what's important in the data. And you need that kind of vision when you start preparing the data for AI. The privacy laws have also had a huge impact. No longer the necessary data minimization. So the privacy, the GDPR and all the privacy laws have had a tremendous impact on how records managers view the world. And instead of keeping, we have come to learn that deletion is the ultimate sign of trust. You can say to your customers, to your employees, we value the relationship so much that we actually are ready to let go of certain data in your interest, not in ours, because if we keep the data, we could make more money. But we want you to trust us, and that's why we're letting go. And deletion really means irreversible deletion. It means letting go. It's not coming back. If someone ever tells you, yeah, let's do a soft deletion, you're archiving, you're restricting access, it's still there, and it doesn't count as deletion. You shouldn't be able to get it back. You haven't deleted it if it's still on a backup. I'm still very much in favor of a backup, guys. We're called filerskeepers. Yeah, I'm not here to get rid of all your data, but if it's time to go, it's time to go, and it should be auditable. You should be able to say, "Hey, we've gone through all these steps, and at the end of this, going through this whole process, we're able to confirm that the data is actually gone because it's a tested methodology." And it's the same with anonymization. It should be both irreversible and auditable. There are some nuances here, both in European and US and international guidance, as well as in case law. And we are kind of bringing a few nuances here, but it's still, anonymization is a very, very hard standard, and it changes all the time. And with AI, it's also becoming more difficult because you can re-identify people. So one of the things that we have been diving into, and after this, I'm finally gonna tell you more about how long to keep AI prompts and all of that. I wanted to set the scene a little bit, but we're almost there, guys. So what is necessity? Because the GDPR and a lot of GDPR inspired laws are saying something like thou shalt keep data no longer than necessary, than for the purposes for which you have collected or processed those data. And that means that you need to have a purpose, and you have to actually specify the business need for the retention period. Yeah, that's a little bit slightly different than the purpose. The purpose could be for recruitment, and the retention period could be 2 years, because and then business need, I still want to be able to reach out to someone after we may have denied them. I can give them an offer for something else. So that's the reason why you want to keep it this long. But the business need is not the same as necessity. Necessity means, what if I turn it upside down? What if I would say it would be 3/4 of the duration? It's not going to be 2 years. It's going to be 18 months. Now, what would happen? Yeah. Then you should be able to show by means of an example or statistics what's going to happen if you reduce the retention period to 18 months. Then something is going to break, usually. So then that's what necessity means. It's causality in a way. So something should break if it's shorter. If you can't prove that, you could probably keep it shorter. Now, this is a way of looking at things, how regulators would love you to look at it. I'm not saying you should. I think not always. But if you are in a discussion with a regulator, then know that this is what they're looking for. So how long to keep those prompts? Yeah. And this is a topic that's still very much in flux. Okay, I'm gonna give you some principles, some guidelines, but today I'm not gonna give you the final verdict. Like, it's gonna be this long. Longer than that is non-compliant. Shorter than that is non-compliant. I can't say it that, but I can say what we're seeing right now, and I will be specific. So, prompts and chats are personal data, guys. Either through the chat, the user identifies themselves. That can be like, my name is blah, 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 make me a CV. Yeah. It can be linked via the account. Yeah. So it's actually user X asking all these questions to the chat, giving all these prompts. That already makes you, because it kind of, if you look at capital France, Paris, and then you book a ticket to go to Paris, then that gives it gives even a richer context than we ever had on someone's behavior. And the chats feel sometimes, I don't know if you are chatting with AI, can feel a bit intimate, right? And some of these AIs are even designed to be super intimate, and give you the feeling that you have a personal relationship. So you will share more potentially as well, which is because of probably a false sense of security. You drag in a few names of some third parties, and you just have to know that even if you try to do this very pure, pseudonyms, it's the Breyer principle, which is a case from the Court of Justice of the European Union. If you can have the legal means to identify someone still through pseudonyms, either by bringing databases together, then it's still personal data. And the other point I already made. So I got a question. Some custom prompts create dashboards or ongoing analysis. Yeah, with the run-of-the-mill request. And then ChatGPT Copilot only allow one retention. Yeah, that is a problem. Definitely. One of the things I wanted to to bring up. I'll get into that in a minute. I'll not forget your question, Nalin. Thank you. So, well, the new AI Act, or not so new AI Act, well, it's still new. It feels new because not every part has, come into effect yet. So in that sense, still new. I have to say something. We serve over 4,000 multinationals, and I think only 3 of them came to us and said the AI Act applies to us, which I think is probably heartbreaking for the European Commission, that thought that at least a quarter of the union would be covered by this law. Everybody's kind of covered, but nobody feels like they're a deployer or of a high risk system. So that's still, but I think it's a moving target. We'll probably the numbers will go up. But one of the things that the Act says, you should have risk management. You should check the quality and relevance of data sets used, technical documentation, record keeping, transparency, provision of information. So there's a lot of focus on actually information governance, records management. And the AI Act has a lot of rules for retention. Some of them even apply to you. We'll get into it. Most of it won't. Yeah. So, and I'm not here to come and say that the AI Act always applies to you, but I think it's important that we know that the idea of the AI Act is really keeping the records so that you can be audited properly. So what are the 3 forces? Pulling at the chat history, one of is the model quality, right? Longer retention, you can improve and create more capable models. Abuse detection, of course. You want to be able to flag the content, to inspect the content later on. But you also want to give the users control. So, data minimization, right to erasure, all of that beautiful stuff. But these are kind of like the 3 main themes. And I think OpenAI had a pretty solid approach there. They had a 30-day retention period until the New York Times sued OpenAI in 2023 for copyright infringement. And then there was a preservation order by the court. Well, the preservation order isn't that unusual, to be honest, but it's what happened during discovery. So the court issued a preservation order to directing OpenAI to retain all output log data that would otherwise be deleted, and that was all except for EU, UK, and a few other countries where there were GDPR, considerations, where the US judge would not be able to issue such an order because it wouldn't be applicable under those laws. And that meant for all of OpenAI's history, because anyone can use New York Times copyrighted materials in their chat. So that resulted in 20 million logs handed over. It was de-identified. That's what they said. We'll never know for sure. But this was a big change because OpenAI had promised everyone that everything would be gone within 30 days. And now there was this preservation order and they had to keep it. And OpenAI publicly fought this. Maybe you've seen it. Sam Altman also posted things on X about this, and how it ended. For now, it got lifted, but it was really also a good reminder that those chats are in fact business records. So what does OpenAI do right now? For the consumer, it's indefinite until you delete. The first few things that I'm going to say here are just consumer retention, yeah, and then I'll zoom into enterprise. But this is kind of it, and it's one retention period, so you just have to choose. So that's also what Nolene said. We can't choose. Yeah, you can't make distinctions between the types of processing within an OpenAI or an Anthropic. It's all or nothing. There is no granularity there. So that's how we get here the 30 yeah, and then with the API data, it's 30 days then deleted, and you could opt in for a 0-day retention period for enterprise customers. You can also opt out. And then Anthropic has an interesting thing where it's 30 days by default, but then but it's also indefinite until you delete. But you could also opt in for 5 years, de-identified, if you want to help improve Claude. And then API data has 30 days. Google has 18 months by default, adjustable to shorter, which is 3 months, and then longer, which is 36 months. And you can even have a 72-hour minimum when activity is off. But this is the consumer version, yeah? But I just wanted to, I know that this is not what you guys are interested in, but I did want to kind of show this to kind of benchmark, so you see what they have. But then enterprise tells a different story. There's no training by default by OpenAI. The standard is 30 days post delete, but you can, but it is indefinite until that moment, unless you set the retention periods. In Copilot, I think it inherits the purview retention, so that's here. And then it's as per purview, so that's where you can manage it in a bit more granularity. Same goes for Anthropic. And with Google Gemini, it inherits the workspace retention periods. Yeah, so you have to set it up for your workspace tenant. So that's important. So what do you have to do? Say you have full control, and you do, in certain circumstances, have some control. You're using AI, but you're not a high-risk system provider or deployer. Yeah. What we're seeing right now is a few things. If you can, and Nolene's point shows that you can't always distinguish by purpose, but if you can, then what we're seeing, and the bandwidths are still very broad, is that for general working chats that you don't use for specific projects or for specific dashboards, more like it's more casual queries, so to say, to assist someone, we see somewhere between 3 months and 36 months. 3 months, very e-discovery minded companies, privacy minded companies. 36 months, more like operationally minded companies that just want to be able to look back in the history and go back a substantial time. Some of it is definitely useful. I love to sometimes go back and search and find an old project, but the usability of some of that work drops significantly after, let's say, 1 or 2 years, because the models improve so drastically that the output isn't interesting for us anymore, if it becomes too old. Then the standards is somewhere, standard stuff like projects, contracts, financial decisions, HR matters. You could technically say that kind of starts to follow already a little bit the considerations of your general retention schedule. it's part of your work. So it kind of follows those purposes, those business functions. And there we see longer retention periods, somewhere between 2 and 10 years, but only if it's truly relevant for that project, for that contract. Otherwise, we're still in the 3 and 36 months area. And if you are in a financially regulated space, then you're in financial pharma, whatever it is, then the AI Act already tells you you should look at your industry regulations, and those usually sit somewhere between 5 and 10 years, plus years. Yeah, it really depends on the purpose, but this is kind of like the idea that you need to, for your like chats and your AI agents and your dashboards, you need to start thinking about, is it kind of like more casual, or is it super regulated? Because if it is part of your correspondence with your customers, it just falls under MiFID 2, falls under SEC 17A-4, and all those other thousands of rules that could possibly comply. Training records, we see somewhere between 5 and 7 years nowadays, can still change as understanding starts. Policies are just the same as policies at the moment, so that's usually in force plus kind of like a statute of limitations kind of retention period, so a couple of years. And then with the training corpora, that one is still quite up in the air. If the AI Act applies, there's a very strict rule, but otherwise just follows the content basically. And then what we also see is people starting to kind of like, oh, what if we just align AI chat logs with like communication retention, like email chat in the schedule, AI literacy training? Why can't we just align it with compliance training, policies with governance, for contracts with contracts, AI incidents with IT security incidents? Yeah, so to kind of get some harmony across the schedule. I do believe this could make sense, but you need to really clarify it in your schedule, because if you fall under the AI Act, they really want to see that it's part of this. Yeah, so you can't argue this after the fact. So you need to actually clarify that with communications retention, you also mean the AI chat logs, for example. So what if the AI Act applies in full force? So what if you are actually, a deployer or a provider of high-risk systems or Gen AI or what have you? Well, then the AI Act has 28 retention obligations for you. It's a true retention Valhalla. None of the laws of its kind have such elaborate retention obligations. They're all in our dashboard, of course. But the longest archive rule is 10 years. We call kind of like the documentation wall. It's your quality management system. It's your technical docs, declaration of conformity, all of that stuff. Long period, 10 years. And then you also have the shortest. There are two like operational logs, automatic logs for providers, deployers, which could be extended by GDPR or by the sectoral rules. And then you have a few that say get rid of things immediately, must delete as soon as the purpose expires. And then we also have about 11 rules that are unspecified. So that doesn't mean keep forever, by the way, guys, but you do need to set a retention period yourself. So who carries that burden of retention? Mostly the providers of high-risk AI, but also importers, authorized reps of high-risk AI, and then of course the general purpose AI providers need to keep stuff for a long time. And then a deployer of high risk, only the automatic logs. And then you have a few carve-outs for financial institutions and pharma that can rely on their own rules. And then you also have some sandbox stuff, and that needs to be all immediately um, deleted. So I think it's very important for you guys to determine, to keep checking if you're now doing something that actually triggers the AI Act. If it does, if you're come to us or go to your My Schedule and literally add the retention periods for the AI Act, it's all there. I have a few more slides on the future of records management. I'm happy to answer any questions as well. I think I just wanna I won't do them all. Oh, I got a question. So when you say that unstructured data is going to be eliminated, what do you mean? What would this look like? That's what Ken asks. I believe that with the onset of AI and more advanced discovery tools, we can literally add the metadata that would structure unstructured data, and to then rearrange that data into a more structured format. So to derive keywords, topics, and how that looks like is through provenance, through adding who created this information under what authority, why was this information created, when and where was it created and used, who has held it, what's the relationship. Yeah. So what we want to do with the information, this is where I think this is going, is we want to understand the origin, purpose, context, the custody, the integrity of the data, and we call that provenance. So in an age of AI, you really want to understand better the authenticity and the integrity of that information. So I believe that we need to go to a deeper understanding that goes beyond data lineage. Data lineage sees to structured data mostly. Provenance could add this to your average Microsoft and Google tenant. And then what is ontology? Ontology is the other framework, and it really explains what are things, how do they relate, and what rules govern them. And that could create a knowledge graph for AI. So it's provenance that gives you the backstory of the record and the integrity of the record, and it's ontology that tells you what was happening within our organization at any given time. What were the reporting lines? What were the projects we were running? Who was involved? What was decided? All of that. If you map those things together, you get a super granular view of the world. So I want to give you and this is my last slide I'll be showing you. You could create a knowledge graph out of that, and then AI won't guess the full meaning of the record, but it will become, with ontology, this is a contract created by legal by this person, related to this vendor, governed by this policy, it's under a litigation hold, and it's connected to this one invoice. And maybe you could go on and on and on. And the CEO emailed the CFO about this, and this lawyer negotiated the contract, and this was decided at this moment. Yeah. If you know all of this, then your AI will be very, very advanced. So that's what I mean by, can we structure unstructured data? Yes, I think there is a lot to do here still. But I think we can get there. Yeah. And we need AI. Funnily enough, it's a bit of a cycle. Then, how do you? A question from Nicole. How do you approach retention when AI logs may contain both operational value and personal sensitive data at the same time? Well, that's kind of like the story of the GDPR. Data has a value. That's why you want to keep it, but you can't keep it forever because there's personal data in there. There's sensitive data in there. You need to think even further. But I think that's where building a retention schedule that includes AI, prompts, logs, training documents, everything is very important. All right. I do want to give you a few minutes back. Are there any other questions still? Oh yeah, I see one from Ken. So that's essentially what we do laboriously, manually, and incompletely by creating a file folder and then applying classification to the file folder. Yeah, definitely. Yeah. The funny bit is that nowadays people are like, all those super cool AI lawyers are suddenly realizing that those records managers weren't so bad after all. And yeah, you need to structure it and put things in files and folders. Yeah. But it's crazy to see if you ask Claude to organize your mailbox, it does that, and it does it very well. So it could very well be easier than we think. Yeah. All right. I can talk about these topics forever. So I'm not gonna. I want to thank you all very, very much for joining this webinar. I hope it was of some use to you guys. I would love to speak to you one-on-one in the future. If you are ever at a conference, we're going to Dublin for the IPP, the AI conference there. We're going to Legal Tech Talk in London, both in June, and we'll also be going to ARMA and to all the other big IPP shows. So find us there, chat us up, call us, email us. We're happy to talk. All right. Thank you. Have a wonderful day.